Morning.
Good morning.
We're here today in docket number SB 2015-06, Invenergy Thermal Development LLC's application to construct the Clear River Energy Center in Burrillville, Rhode Island. This is the beginning of the final hearings. We will, as you know, start today and go on into the foreseeable future. We are only two members of the board today. As you are no doubt aware, we've lost our other member. We will continue nonetheless. We still have a quorum with two. Today, we have some procedural matters and some motions. Before we get started, could the parties introduce themselves for the record?
Good morning, Madam Chair. On behalf of Invenergy, Alan Shore, with me today are also Nicole Verdi, Elizabeth Noonan, Richard Beretta, and also with Invenergy is Invenergy's counsel, Michael Blazer. Good morning.
And John Nyland.
From the company. John Nyland from the company.
Your Honor, Greg Nancy from the building trades.
Andrew Marcaccio on behalf of the Office of Energy Resources. Here with me is Deputy Commissioner Nicholas Succi.
Good morning, Mike McElroy for the Town of Burrillville.
Jerry Elmer for Conservation Law Foundation.
I don't think your microphone.
I apologize, Jerry Elmer for Conservation Law Foundation.
Madam Chair, I just wanted to say good morning, and I wanted to commend Parag Agrawal for his service on this board. It's important work, and I just want to acknowledge his service. And I know that the Department of Administration is posting that Associate Director of Planning position and seeking to fill that. As you mentioned, we have a quorum, so we're in good shape to continue on with our business.
Yes, which is not to say we don't miss our former member. And now I will ask counsel if there are procedural matters.
Yes, there are a number of procedural matters. The first one is all of the parties have submitted exhibits. All of the exhibits will be marked for identification. I believe that there is no objection to any of those exhibits being marked full, with the exception of town exhibits 20, 21, and 22. There were resolutions submitted, municipal resolutions previously submitted, that the board previously ruled in Order 119 and held that those three documents or groups of documents would be treated as public comment and not as full exhibits. With the exception of those, I believe there is no objection to all of the other exhibits being marked as full. And I would just verify that with counsel.
Is there?
That accurately sums up the status of the exhibits from Invenergy's perspective. Thank you.
Council, I believe Town 20, and I don't have the package, but I believe Town 20 contains the Burrillville resolution in opposition to the plan. My recollection of the board's ruling in that order is the Burrillville resolution would be accepted as a full exhibit, but all the others would be only for public comment. So with that clarification, we're in agreement.
Invenergy we also concur with that representation that is accurate.
I think that exhibit should be taken out of the packet and marked as its own exhibit then. given its own exhibit number.
No objection.
And
Okay, I can do that.
I can talk to you about that afterwards,
That's
just so
fine.
that it's separated from the packet.
That's fine, thank you.
Do other council have any position?
Oh, yeah, there's no objection.
No objection. No objection.
The second procedural matter is, it's my understanding.
So, let me just say then, with the exception of, at this point, should we include 20 as well as 21 and 22, which will remain marked for identification? The other exhibits are all marketable.
Thank you. And then once we assign the Burrillville resolution and exhibit number, we can mark that as full also. The second procedural matter, I believe that Invenergy will move to strike all the references to the Narragansett Indian tribe, specifically September 28th, 2017 Water Supply Plan Supplement, the ESS report titled Proposed Water Use Form from Lower Wood Watershed that was filed on October 24th, 2017, and that is not listed as an exhibit, and its responses to town data requests 40-1 and 40-2. I don't know if any of the other parties have any objection to that, or if that was discussed with the parties. It's my understanding that Invenergy will make that motion today.
Yes, we do move for that. We didn't discuss it with the parties, but because we are no longer proposing to obtain water from the Narragansett Indian tribe, all of this is irrelevant. We move to strike.
Two things. First, CLF has had no notice of the move to strike the references to the Narragansett water contract. Second, we do object to striking those references for the following reason. Invenergy made a colossal error in entering into that contract, putting that contract before the board in the circumstances that it did. It is, of course, understandable that Invenergy would now want to strike those references from the record, but those references are in the record. They were put into the record by Invenergy. The EFSB should consider the totality of the circumstances, including the multiple errors that Invenergy has made negotiating the EFSB process. This is one of them. I understand that the contract has been withdrawn, but that doesn't mean we strike from the record any references to it having been entered into and put before the EFSB by Invenergy.
Madam Chair, this is, again, the first I've heard of it. I haven't seen anything in writing. I haven't been able to go through the record with the references that council read to determine whether or not the town has an objection to this. I would suggest that this motion be handled in the usual fashion, that Invenergy file a motion, that we be given the appropriate period of time to respond, to check the references, to determine what our position is. And we do have another hearing coming up on the 26th, where I understand we'll be giving opening statements. I would suggest that we have oral argument before the opening statements begin on that motion, and we have a chance to look at it and respond.
That's fine. We would join in that recommendation. Of course, we object to some of the characterizations of the information by Mr. Elmer, obviously.
I think we'll be doing that a lot in this hearing.
Why wasn't the motion filed like originally?
Madam Chair, it was because I thought it was more housekeeping, and this is no longer CRC's water supply plan, so to clean up the record, I wanted to put a motion to strike because I believed it to be more housekeeping. If others believe it's more substantive, then we can definitely make the written filing, but it appeared to be more of a housekeeping matter.
Council, any position?
No position. No position, Your Honor.
OER has no position.
All right, well, since Invenergy has indicated that it can go forward and file the motion like a regular motion, we'll do that.
The third procedural matter is regards the joint motion to stay that was filed by CLF in the town, where they moved to stay pending conclusion of the FERC proceedings. By email dated yesterday, I was informed that the town and CLF are withdrawing this motion. The fourth procedural matter concerns the motion to release the redacted portion of Glenn Walker's testimony. And it's my understanding that the parties will speak on that, and they came to an agreement regarding that, and we'll put that agreement on the record.
May I pass out a revised Exhibit A that was filed to our objection originally that we've agreed with?
On which motion is this?
That's the motion to release the redacted portion of Glenn Walker's testimony.
Before we go to that motion, can we address the resolution, if indeed there is one, for the motion to stay pending the conclusion of the FERC proceeding?
That was withdrawn.
Okay.
They agreed to withdraw that one.
Do we have that on the record?
They sent me an email yesterday afternoon indicating both CLF and the town that they were withdrawing it. So I guess they can confirm that.
I can confirm that we're withdrawing that motion. The FERC proceedings are concluded.
And I certainly confirm for CLF that that motion has been withdrawn. It is moot. And Ms. Lucarelli represented that accurately.
Thank you. Okay, then on to the redacted portion of Glenn Walker's testimony.
Yes, this was CLF's motion to unredact formerly redacted portions of the September 2017 and February 2018 expert testimony of Burrowville's witness Glenn Walker. Since Sunday, I've been corresponding with Mr. Shore, and we've come to a complete agreement on how the various portions of Mr. Walker's testimony are to be treated. That agreement is reflected in the revised Exhibit A that Ms. Verdi passed around a moment ago. As you can see, with regard to the September 2017 testimony of Mr. Walker, all of those previously confidential sections are now to be released publicly. With regard to the February 2018 testimony, each separate portion is to be handled in the manner reflected on the Exhibit A. This does represent an agreement between Invenergy and CLF. I just want to point out, for the record and for clarity, what the two differences are between the Exhibit A passed around today and the previous Exhibit A that Invenergy circulated on March 14th. First, there were, Invenergy made two inadvertent errors in the earlier version of the Exhibit A, which we pointed out to them and have been corrected. The first inadvertent error was that they were suggesting that the September 2017 QDN, that's qualification determination notification from the ISO to Invenergy for forward capacity auction 12. In the earlier version of this exhibit, Invenergy had said that that was going to continue to be confidential, but they had actually already released that publicly, the first 3 pages. The second inadvertent error was that Invenergy had neglected to say that they want to keep the chart on page 15, lines 14 to 26, confidential, but they do. That is a chart pertaining to the minimum offer price rule and the offer review trigger price. The offer floor price is set by the internal market monitor. The way I put that to Mr. Shore in the email, but I won't say here, knowing of the chair's allergy to acronyms, is I said to Mr. Shore that that deals with the MOPR and the ORTP, and the OFP is set by the IMM. with those.
My problem with acronyms is not really an allergy, that I think that what we do ought to be understandable for virtually anyone who's interested, and it's frequently not when there are acronyms.
And CLF agrees with you emphatically. With those two differences noted, CLF is prepared to stipulate to the revised Exhibit A that was circulated this morning and would ask the EFSB to approve or ratify that so that we're all on the same page with regard to what can be released.
My brother, Mr. Elmer, has kept the town apprised of these negotiations. I have reviewed the revised Exhibit A, and the town is prepared to stipulate as well.
Just for the record, before we move on, I just wanted to note an objection to the characterizations that were made with regard to inadvertent errors with regard to some of these documents. I don't know what the details are with reference to that, but we reached an understanding that several of these documents would be available for the public review as part of the process. That was the extent of our agreement with Mr. Elmer, so I just note that objection.
What's the precise nature of the stipulation?
I believe that CLF and Invenergy are stipulating to handle Glenn Walker's pre-file testimony of both September 2017 and February 2018 in the manner set forth in the revised Exhibit A handed up to the bench by Invenergy's counsel a moment ago.
That's correct.
And council agrees with that as well?
Yeah. Yes, Madam Chair.
Thank you very much.
Is that approved by the EFSB?
Yes.
Thank you.
So the motion can be withdrawn.
Yes.
The next procedural matter is a motion that was filed by CLF for an express EFSB statement on the applicable cost standard for the Invenergy application. In response to that, Invenergy filed a response to that motion, and I believe that the party should be voted on it.
Thank you. As the EFSB is aware, this is a very short motion without the caption. It's less than 2 pages. All we're doing is asking the EFSB to make an explicit statement in its final order after the final hearing as to the applicable standard of review that it applied to the cost of the plan.
How is this appropriate now?
Here's how it's appropriate now, in its response on March 14th, Invenergy was careful not to object to the motion. In fact, Invenergy said specifically, filing a...
But that's not what I asked. Why is it appropriate now to have a motion about something that is included in the statute that governs the Energy Facilities Siting Board? We haven't had any evidence. It seems to me that it's completely premature. If there are arguments about the nature of the cost standard based on evidence that's introduced during the final hearing, and how it should be addressed ultimately in the final decision that the board has. Why would we address that now?
Respectfully, Madam Chairperson, CLF is asking the EFSB to address that now because we believe that the disagreement inevitably inures in the case. CLF has said that the applicable cost standard appears in the statute. In Invenergy's response, which was not an objection, they cited 3 cases on page 3 of their response: the Tiverton Power case, the Indec North Smithfield case, and the Rhode Island Hope Energy case, to suggest that there is a different standard. The based standard is a result of deregulation of electricity utilities in Rhode Island in the 1990s. And our concern is that unless the EFSB makes an explicit finding in its final order, the lack of clarity is going to make it impossible for the Supreme Court to review the order, thereby causing a remand and unnecessary delay. The reason we're filing it now is to call attention of the EFSB, of Invenergy, of all of the parties to what we believe is the standard of law reflected on page 2 of our motion, as set forth in the Atlanta College of Medical Careers case, that says agency decisions must provide an explanation sufficient to permit a reviewing court to determine whether or not a decision was based on the correct standard. And since this case has started, there has been an ongoing disagreement as to what that standard is. Note that CLF is not in this motion asking the EFSB to rule that CLF's view of the standard is correct and Invenergy's view of the standard is incorrect. All we're asking the board to do is to say, yes, when that final order is issued later this year after the final hearing, we will address and resolve that issue. We will state clearly in our final order what our standard is. CLF's fear or concern here is that if the EFSB does not so clearly state what standard it applied, when this case is appealed to the Supreme Court, we're going to be risking a remand to the EFSB, not because you made the decision wrong and not because you set the standard wrong, but merely because you didn't say clearly what standard you were applying. And that sort of delay for a remand will not benefit Invenergy, it won't benefit the parties, it won't benefit the EFSB. We're not asking you to agree that our view of the standard is right. We're asking that in your final order, you set forth what the standard is so there can be a proper and orderly appeal based on everyone knowing what standard you did end up applying.
Mr. Elmer, what confounds me about the motion is the standards are determined and set out in the statute. And I feel like you're trying to persuade us to use the standards under the Energy Facility Siting Act and to make sure that we explain the decisions that we make relevant to those standards when that is exactly our charge.
Director Coy, on the one hand, I agree with you emphatically. The standard is set forth in the standard, and in fact, Invenergy on page 1, paragraph 2 of its response says, and I quote, "Pursuant to the Rhode Island Energy Facility Siting Act, the board must apply the applicable statutory standards to the facts and evidence presented when rendering a decision granting a license," unquote. However, in the very next sentence, Invenergy says, the board does not need to make an express EFSB statement on the applicable cost standard. And that's what worries us, because if the EFSB does not make an express statement on the applicable cost standard, it'll be impossible for the Supreme Court to review whether the board used the correct standard.
I think that it's awfully premature to worry about the contents of the final decision when we haven't heard any evidence at all. And you're suggesting that there is some bearing on the contents of the final decision based on what we say today we will include in the final decision. Again, before we've heard any evidence at all. Do other council have any comments on this motion?
I'd like to just reiterate, that this is a premature motion. Also, just to make it clear for the record that, as we pointed out in the first paragraph of our response, we did request that the board deny this motion. That is, that the motion asking for the board to make a statement now before we've even begun the evidentiary hearings is premature, it's unwarranted, and unnecessary. So we have objected to the request or the motion that you make a statement now at this time. I should also point out that you already have made a statement with regard to the applicable cost standard in your preliminary order. When we had a preliminary hearing, the board rendered a decision on preliminary order where you outlined the statutory criteria, the particular statutory criteria with regard to cost that is the subject of this motion was explained in your preliminary order, was referred to the Public Utilities Commission for a review specifically on those aspects. There was no such motion or articulation of any need for the Public Utilities Commission to investigate or further explain its view of the cost standard as in the statute. There were no briefs filed by CLF to take a position with regard to that. So it's just it's a curiosity, honestly, at this point, why this motion is being put before you at this time. We have full confidence that the board will hear the evidence, will hear the articulation of the evidence by the witnesses, and it will render a decision with full account for the statutory standards that are in place in the law at this time, or at the time of the final decision. And so, with those applicable statutory standards already in the law, and as explained in your preliminary decision, and as further explained in the advisory opinion that you received from the Public Utilities Commission, we do believe that the motion should be denied, as it is unnecessary for you to render any further decision with regard to the cost standard that's in in the siting board statute. Thank you.
Do counsel for any of the other parties want to be heard on this?
Just a quick comment, Your Honor. I don't do a lot of civil practice, but I have never heard of anything like this before. I do some civil practice. I think this would be the only time that such a motion would even be asked and or granted. So that's it.
No comments.
The town supports CLF's motion, and while we are fully confident that the statutory standard will be applied by this board, there will, at some point in time, be a question of whether or not the Utility Restructuring Act either implicitly repealed or had an effect in some way on the cost standard and the need standard in the Energy Facilities Siting Act. That is what we're heading down the road in the presentation of evidence where that question is going to become important. So whether we, deal with it now, or whether we deal with it later during the evidentiary hearings when the cross-examination on this particular issue arises, or whether we deal with it in final briefing, this is going to be an issue. I think it was important for CLF to alert the board that this is an issue. I think the papers that were filed show how it's an issue, and there has been suggestion that the Utility Restructuring Act constituted an implicit repeal in certain aspects of the Energy Facilities Siting Act. We do not believe that's the case. I believe everyone here is in agreement that the statutory standard, which has never been amended since the act was passed, that statutory standard still applies. That the Energy Facilities Siting Act has been amended a number of times since the Utility Restructuring Act was passed, and the standards that need to be applied were never amended. Therefore, the legislature has reaffirmed those standards. So we're confident they'll be applied, but I commend my brother for bringing it to the attention of everyone here, because it is going to be an issue. It's a question of when do we deal with it. Thank you.
I would move that we deny this motion to the extent that's ever appropriate. It's premature now. What should or shouldn't be in the final decision should be addressed at the close of the evidence. Such concerns about the final decision are just not appropriate to be addressed at this time. Whether or not the matters that have been addressed dealing with the appropriateness or the continued appropriateness of the statutory language that has been, as council has noted, reviewed by the legislature a number of times since the Restructuring Act. It is just not an issue before us at this time. It certainly should be addressed at the close of the evidence. Certainly concerns about appellate review are not appropriate at this time either. So for all of those reasons, I move that we deny the motion.
I'll second them.
All in favor?
Aye.
That brings us to the final motion, also the Conservation Law Foundation. The motion to dismiss.
I believe that Mr. Elmer had asked that this motion not be heard until after the conclusion of the evidence. I don't know if the board had any questions regarding that. And I do know that Invenergy has filed an objection to the motion alleging that it was procedurally defective. and asking that if the board choose not to rule on it at this time, that they be given the opportunity to further object to address what they claim to be substantive issues also.
If the chair wants, I'm happy to address the timing issue.
Well, you can address the timing issue because I'm inclined to dismiss it, if only for the timing issue. You can bring it up again when you think the timing is appropriate for consideration.
The basis for the motion, as the EFSB knows, is that the only application pending before the EFSB is for a 2-turbine, 1,000-megawatt project. The only evidence that Invenergy has put in so far pertains to a 500-megawatt, 1-turbine project. There is evidence in the record that the second turbine will never clear in the ISO auction. In fact, just half an hour ago, the EFSB unredacted that testimony from Mr. Walker on pages 4 through 6 of his February testimony. The reason that CLF filed the motion now, asking specifically that it be heard only after the final hearing ends on October 31st, is out of respect for the view of the chairperson that the applicant is entitled to a final hearing. The reason we filed the motion now and asked for a hearing after the final hearing was in order to alert the board, to alert Invenergy, and alert all of the other parties that this issue inures in the case. We think that there's a substantial benefit and advantage to the EFSB to ruling on the matter only after the final hearing, because there will be at least 3 important data points in the record of the case at that time that we don't have now. First of the 3 is that on Friday, September 28th this year, the ISO will issue its qualification determination notification for the participation or non-participation of Turbine 2 in the upcoming Forward Capacity Auction 13 next February. Second, we'll know by October whether or not the ISO has invoked the provisions of the ISO tariff, Section 3.13.4C, to involuntarily discontinue the capacity supply obligation that Invenergy acquired in Forward Capacity Auction 10 of 485 megawatts. And third, Invenergy, as of today, continues to assert and to tell the EFSB, to tell the ISO, and to tell the world that it can be online in June of 2021. There's considerable doubt as to whether or not that is legally possible. There's considerable doubt as to whether or not that is physically possible. But by October 31st, everybody in the world will know whether or not Invenergy can be up and running in June of 2021 as it asserts it can be. Those 3 data points will be important to the board in making a decision on the motion to dismiss. In opposition to the motion to dismiss, Invenergy says on page 1 of its opposition, Rule 50 is inapplicable. And of course we agree, there is no civil procedure Rule 50 here. We're not invoking a rule that isn't here. What we're saying is, if Invenergy has not met its burden at the end of the final hearing, the application should be dismissed without troubling all the parties to do final briefs. Invenergy says on page 3 of its opposition that the motion is premature and speculative based on anticipated evidence. And of course this is anticipated evidence, and that's why we're asking that the motion be heard after the final hearing, on or after October 31st. CLF believes that we are helping the process here by alerting the parties, alerting Invenergy, alerting the EFSB as to what the issue is here. The issue is that the evidence may not be matching the application. The application is for 2 turbines, 1,000 megawatts. There's no evidence in the record, and there won't be on 2 turbines, 1,000 megawatts. We believe it's helpful to the EFSB proceeding that everybody know that this issue is pending and will be addressed after the final hearing.
Mr. McElroy.
Thank you. We support CLF's motion. Particularly, we believe the appropriate time to hear the motion, as CLF has requested, would be at the close of all the evidence. Whether that's done by holding this motion and then hearing it when the evidence closes, or by dismissing this motion without prejudice to refiling it, I think is just a procedural matter. But we support the matters set forth in the motion. If the evidence stays as the pre-filed evidence currently is, we support CLF's motion in this regard. We also support having it heard at the close of the evidence. Thank you.
Madam Chair, on behalf of Invenergy, we object to this motion and we ask that it be denied. Not only is it premature, as was the prior motion of CLF, it's not applicable. Rule 50 does not apply to EFSB proceedings, and even if you do somehow coach out and say Rule 50 does apply, Rule 50 only applies in matters by jury trial, when you take it away from the jury. That simply is not the case in this proceeding here. What it appears happened with that motion and this one is that although today was the first day of our final hearings and opening statements were supposed to be on April 26th, CLF has decided to commence its opening statements today through these motions that are brought before you. And we believe that's inappropriate and that these motions should be dismissed. They are highly speculative and premature, and all of this information will be dealt with at a later time in the probably post-hearing briefs or however the board wishes to characterize it. But I think Mr. Elmer knows that this type of motion is not set forth at all in any of the rules. Even if it were, it's not applicable to this proceeding and is certainly by his own admission premature. Yet he was able to get points forward to this commission prior to oral argument, opening statements rather. He even said that he wanted to call attention to some of these issues. That's the purpose of opening statements. That should be appropriate in a few weeks, and we would ask that this motion be denied today.
Your Honor, just that we join Adel Pollack or Invenergy with their objection.
No comment.
Madam Chair, I just want to say that I'm very confident that on April 26th, Ms. Noonan will be able to discern the difference between CLF's opening statement and its argument on a motion.
I think we should also deny this motion. Everyone seems to be in agreement that it is speculative at this point. One can be based on material matters that are not speculative. It can be renewed until that time. I would move that it be denied.
I agree, and I'll second your motion.
Any discussion?
No, I think the points have all been made, and perhaps we'll see something similar later in the process.
All in favor? Aye.
Aye.
Is there anything further?
That will conclude the procedural matters. As was just noted, April 26th, the parties will all make their opening statements. Those opening statements will be limited to each party that is pre-filed testimony to 1 hour and a half.
One question, we did have one issue that we agreed on the Narragansett Indian tribe would be, I believe, coming to us in the form of a motion with arguments. Will we hear that at the very beginning of the next meeting before we go into the opening statement?
That's entirely your prerogative, but I would suggest that.
We can do that.
I'm prepared to make a motion to adjourn until the 26th. Is there more that we need to handle today?
Do we need a motion to adjourn or just a motion to continue?
You don't need a
Okay, is there any other business before? Then I would make a motion to continue this hearing until April 26th when we meet again in this room at 9:30 a.m.
I would second that. All in favor? Aye.